Good afternoon, everyone. We are on the record in case number 22 CR 21679, State of Oregon versus Michael Bivins. This is the time set for sentencing. Counsel, would you please identify yourselves to the record?
I'm Quinn Zemmel, ZEMEL, bar number 155173 on behalf of the state.
Alicia Hersher, HERCHER, bar number 060722 for Mr. Bivins, and we're ready to proceed to sentencing.
All right, so I've received the state's sentencing memo, and I know that we're going to hear from a lot of different people first, I think, but first, Ms. Hersher, do you have any disagreement about the state's legal analysis? I'm not asking you to agree with their recommendation, but just the legal analysis, is there any dispute about that?
No, the only, and I don't want to make too big of a deal about this, but including the allegations in the sentencing memorandum about uncharged conduct of this, yeah, you know.
I will say I appreciate the state bringing up the issue about uncharged conduct, but it's uncharged conduct. I'm not considering that that Mr. Bivins did this. It's not proven.
Right.
So I understand why the state's bringing that up, but that's not going to be a factor in my sentencing. The other things that are factors that are appropriate, but that's not one of them. Okay.
Other than that, we agree with and ask the court to adopt the state's recommendation for sentencing.
All right. So I don't need Mr. Zemmel to repeat anything in the state sentencing memo. I rely on that for your argument and your recommendation. Ms. Hersher, do you want to say anything about a recommendation, or do you want to first hear from the various people who are going to make statements?
No, nothing to say. Thank you.
All right, Mr. Zemmel, is there anything you'd like to say before we hear from anyone who wants to make a statement?
Briefly, Your Honor, yes. I just want to point out, as far as the state sentencing recommendation, that we believe it strikes the right balance between accountability and long-term community safety. When we're looking at what Mr. Bivins is convicted of course, the harm goes beyond the property damage, but also, you know, we look at what his intended effect was and what the actual effect was. And obviously, the actual effect here is far beyond property damage, but also so was his intent, and that Mr. Bivins had done this intentionally with the desire to cause a broader effect on the community, and that justifies a much more severe sentence. But then in addition to the community effect, as far as the targeting of certain groups, there's also the arson factor here, which presents him as a serious danger. If Mr. Bivins is released and reoffend, there's risk not just of property damage, but of significant loss of life. And so it's for that reason that the state thinks that the sentencing recommendation of 16 months of prison followed by a 5-year probation is most appropriate. This would not be a sentencing recommendation that would be available if Mr. Bivins didn't have as much credit for time served as he has. The state anticipates if the court were to impose this sentence, Mr. Bivins would spend a short amount of time at the Department of Corrections. We believe that time is appropriate for him to do some additional time, but would leave enough time for him to have a serious and monitored probation. And also in conversations with some of the various victim institutions, generally speaking, you know, the court will hear from them. There was a desire for some sort of supervision and rehabilitation. I will note that part of why the state is making the recommendation that it is, that includes some additional custody time, is at the moment, you know, there hasn't been an acceptance of responsibility, insight into the behavior, and so more custody time is appropriate, but Mr. Bivins will get out at some point, and getting out to a supervised intensive probation, we believe, is the best path forward.
Who do you have that is going to make a statement today? And anyone on WebEx or just everyone in person?
I believe everyone is here in person, Your Honor. I have 3, it was 4, I now have 3 folks who would like to make statements. Then I have a community impact letter as well that I can read into the record. I forwarded those names up to the court, but I'm happy to name them, or the court can go off.
You can just, whoever you want to call first, you can just have them come to the council table and sit next to you.
Okay. Rabbi Kana?
Good afternoon. If you could just state your name for the record, please.
Thank you. Rabbi Michael Z. Kahana, C-A-H-A-N-A. Good afternoon, Your Honor. I am Senior Rabbi of Congregation Beth Israel in Northwest Portland. Our synagogue is the oldest in the Pacific Northwest, founded in 1858, just months before the state of Oregon. And throughout our 167 years, we've been one of the most prominent and visible synagogues in the state. Some of our past rabbis have been national local leaders, including Rabbi Stephen S. Weiss at the beginning of the 20th century, who became one of the most famous rabbis of that era, and my predecessor, Rabbi Emanuel Rose, who led our congregation for 46 years and was deeply engaged in Portland's civic life. In November of 1938, the entire Jewish community of Portland gathered in Congregation Beth Israel's historic sanctuary to express their horrors at the events of the Night of Broken Glass, Kristallnacht, in Nazi Germany, in which synagogues and Jewish businesses were looted and destroyed in one of the most prominent acts of anti-Semitic terror experienced in modern Europe during that time. In April of 2022, our community gathered in that same sanctuary to honor the memories of those who had perished during the Holocaust at our annual Yom HaShoah, the Holocaust Memorial Day commemoration. That evening, we hosted many of the remaining survivors of the Holocaust who live in our community. These elderly people are the last of our local witnesses to the horrors of Nazi genocide visited on their own families. The very next morning, our staff awoke to find anti-Semitic graffiti in German painted on the walls of our historic sanctuary, which is listed in the National Registry of Historic Places. Those words painted on our sanctuary by Michael Bivins echoed the very language scrawled on Jewish businesses and synagogues during the horrors of Kristallnacht. After documenting the assault and reporting the details to the police, we quickly had the graffiti removed, lest the fact of its presence bring fear into the hearts of our community. My prayer at that time was that none of those Holocaust survivors would see them and become re-traumatized by that experience. The very next day, Mr. Bivins chose to return to the scene and throw a rock through our library window just across from that sanctuary, making clear the connection to the Night of Broken Glass. At this point, we could no longer protect our community or ensure them that they were safe on our campus. Local media reported the story, and it quickly grew to national and even international news. This time came at a time of heightened anti-Semitic attacks, and the Jewish community here and around the nation were already on edge. Just 4 years before Mr. Bivins' actions, the Jewish community in the United States were shaken by the horrific murders at the Tree of Life Synagogue in Pittsburgh. In attacking our historic and highly visible synagogue, in a manner and timing which echoed Nazi Germany, Michael Bivins put our community on edge. He gave the message that the Jewish community is not safe in Portland, and that the horrors of our worst experiences in Europe could be visited on us here in Portland. Over the years since, numerous congregants have expressed to me and other leaders of our congregation their fear to come to our services in person. They have told me how vulnerable they fear in our sacred space. We have invested a large amount of money in security infrastructure, which makes our worship space less inviting, which runs contrary to the American promise that all shall be free to worship in peace. The biblical prophet Micah made a promise. But each shall sit under their vine and fig tree, and none shall make them afraid. And the first president of the United States said these words to the Jewish community of his time. For happily the government of the United States, which gives to bigotry no sanction, to persecution no assistance. The actions of Michael Bivins have undermined these promises to the Jewish community of Portland, Oregon. Its effects and the vulnerability and fears it has invoked to us will remain with us for many years to come. Thank you, Your Honor.
Thank you. Hey, and Rabbi, how do you pronounce your last name?
Kahana.
Kahana. Mr.
And Katie Schneider on behalf of Congregation Shir Tikva.
My name's Katie Schneider, Schneider. Your Honor, thank you for the opportunity to speak before the court. My name is Katie Schneider, and I was the Executive Director of Congregation Shir Tikva at the time of these incidents. I am speaking both on my behalf and as a representative of our Board of Directors. This incident was both painful and alarming for our community. The damage was not just physical. It was not just a broken window for us, but a reminder that we are all vulnerable to being targeted for a set of beliefs or the color of our skin. We appreciate all the steps that have been taken in this case to ensure due process and the enforcement of laws against hate crimes. Our particular religion teaches us to balance judgment with mercy. In a perfect world, the sentence of this court would include an opportunity for all parties to come together for restitution, education, and reconciliation. But we understand that Mr. Bivins has shown no remorse for his crimes and has repeated his threats against minority communities. Therefore, we agree with the prosecution's sentence as the best path forward to safety at this time.
Thank you. Mr. Zemmel, the next person.
Yes, and Andy Green on behalf of the Muslim Community Center of Portland.
Can I stand, Judge?
You may.
Thanks.
If you can just make sure you stand close enough to the microphone so
Sure.
people on WebEx can hear you.
Bismillah ar-Rahman ar-Rahim. Alhamdulillah rabbil alameen.
Your Honor, I would ask that the folks that are giving their statements would address the court, not my client.
So, Judge, this is a standard Islamic way of doing an introduction.
Hold on,
Go
Mr.
ahead.
Green.
Okay.
Hold on.
I can translate it for you if you'd like.
So her objection was that you were addressing Mr. Bivins,
Sure.
not me.
Well, I'd like to address Mr.
He's
Bivins.
taunting.
But I'll address the court, Judge.
Well, I think the best thing to do is, I guess, face me, address
Sure.
me. If at some point
You know,
you need, it's just
there
natural
is a
to
point
turn
where
to him,
I
that's
think
fine.
it is appropriate. No,
Okay.
I understand that, Judge. So, Bismillah ar-Rahman ar-Rahim. Alhamdulillahi rabbil alameen. Kul huwallahu ahad. Allahumma salli ala Sayyidina Muhammad wa ala ali Sayyidina Muhammad wa barak wa salam. Mr. Bivins, I'm honestly, like, I'm really sorry you're in this position, like, on numerous levels. I guess I'm sorry, my name's Andy Green, and I am speaking on behalf of the Muslim Community Center of Portland. I was a trustee until last month. I had to step down for health reasons. And I'm also as a member of the Muslim Community Center. And I feel horrible for you. I really wish there was more that I could do for you.
Save your pity
Okay.
for the weak.
Stop.
Save your pity for the
Stop.
weak.
Stop.
And
But hold on, so Mr. Bivins, you have a chance to speak at the end, before I impose the sentence. I ask that you respect everybody else, you listen to them. You can make, like I said, you can make a statement at the end, but it will not help you if you interrupt anybody, okay?
And I would just reiterate that it would help if the victim impact statements were made to the court, not directly to my client,
I
to
think-
avoid just this situation.
Well, I think what Mr. Green is saying right now, I think is appropriate. It's not inflammatory. As long as he continues kind of with the tone and the language he's using, where he actually is, I think he actually is addressing Mr. Bivins to express whether it's sympathy or whatever it may be, I think that's appropriate. But I just asked Mr. Green to continue on the
Certainly,
path
Judge,
you're on.
and I'm trying to stay at least in this somewhat direction. You know, and in reality, you know, it's the arson. You know, he tried to burn down the masjid. You know, that's mosque. He tried to burn down our masjid while people prayed in it. And if you can look around the courtroom and see how many people from our community came. You know, the only visible Muslim, you know, came with me. So you can see how much of an impact that actually had on us. You know, in a lot of ways, this has been a huge blessing. You know, and in reality, you know, everything's a blessing from God. It's just sometimes we're veiled from that. You know, on a personal level, the only reason I'm here, the only reason I'm involved at this level in our community is because of this very event. I've never been a joiner. I still work for myself. But it was just that motivated me to get involved on a community level, on a I don't want to say leadership level, but on an administrative level. I also feel bad. You know, you've kind of been hoodwinked. You know, the propaganda that Islamophobic propaganda that, you know, do you want to attack us? You know, there's kind of a cosmic irony in this whole thing. You know, if you ever get the opportunity to see where that originates out of, you might find it. I don't know. You just might want to look into that at some point. I will say that you can burn down our masajids. You know, you can kill us. You can do whatever you want, but you cannot terminate. You can't eliminate al-haq, which is the truth, capital T. You know, the ultimate reality. I honestly want you to know, and Judge, I would ask permission on this part. Like, I was going to tell Mr. Bivins that, you know, I forgive you. I know the members of our masajid forgive you. Imam Najib, he died in December. He was a very important figure in my life. I had numerous conversations with him. He's a really funny guy, and he was an old Nation of Islam guy that came to, and it's funny now that if you look at me, you wouldn't think I was Muslim, nor would I be on the board of a old Nation of Islam masjid. But he was like, oh, that poor boy, he's just sick. We don't want anything to happen to him. And I know he forgave you. And I want to invite you, you know, if you're willing, you can pray with us at any time, you know, when you are able. I'd like to invite you to Islam and to forgiveness. You know, I am ambivalent.
No, thank you.
I will stop addressing him. I'm ambivalent on these kind of man-made forms of justice, even though I work in them. But I do. You know, I almost didn't even want to say anything because I knew my concern was that you wouldn't hear anything I said anyway. But all things are possible, and I do want you to know that this community forgives you, and I will pray for you, and I will certainly pray for the best for you. Thank you. Thank you, Judge. Oh, and I'm sorry, and I would be remiss if I didn't thank Mr. Zimmel. He's been on this case for 3.5 years. I'm incredibly impressed with everything he's done. I mean, like the level of professionalism. And so I just want to thank him as well. Thank you.
All right, thank you, Mr. Green. Mr. Zimmel, are there any other people that want to make a statement?
No, Your Honor.
Okay, did you have a letter that you want to read into the record?
I do, Your Honor. Your Honor, we as members of Congregation Beth Israel and Congregation Shir Tikva, as well as the broader communities impacted by Michael Bivins' bias crimes, right to address the impact of his hateful actions and their implications for our future safety. In April and May of 2022, Mr. Bivins set fire to the Muslim Community Center of Portland with congregants inside of it, shattered windows of Congregation Shir Tikva in the Eastside Jewish Commons and Everybody Eats PDX, and spray diluted on Congregation Beth Israel an explicit reference to the Holocaust, the day after the synagogue hosted the Community Holocaust Remembrance Day. His actions went beyond defiling our sacred spaces. He sought to erase our right to practice our religions and to shatter our sense of safety as Muslim, Jewish, and Black people. In addition to these crimes, we were also aware that he was a suspect in, as of yet, uncharged arson attack that occurred during the same period and was aimed at a minority group, which caused great destruction and could have easily resulted in the deaths of numerous people had they not been extremely lucky. The effect of Mr. Bivins' crimes on our communities have been significant. However, we choose not to detail those effects here because we understand this is a public document and we refuse to feed into the white supremacist goal of spreading fear through hate. According to the affidavit of probable cause, Mr. Bivins told a reporter before he was taken into custody that he intended to continue attacking mosques and Black and minority-owned businesses. His many letters to the court over the last 2 years continue to reveal racist and anti-Semitic beliefs, serious mental instability, and an inverted perception of the reality in which he is the victim and the Jews and Chinese pose danger to him. Nothing in these letters indicates that he has developed remorse for the harm he caused or reassures us that he will not return to targeting our communities upon release. We therefore respectfully request that you apply the maximum sentence for Mr. Bivins. Upon his release, we respectfully request that you apply the strongest and most comprehensive supervision possible, with stringent safeguards for our community, including restricted access, electronic monitoring, and prohibitions on owning firearms. We request these measures to protect our community members from the very real threat of physical violence and arson. At the same time, we believe in and pray for the possibility of Mr. Bivins' return to health and wholeness. We respectfully request that you order the maximum possible sentence of psychiatric care, rehabilitative treatment, supportive, supervised housing, and intensive support to give Mr. Bivins the best opportunity to regain his stability. Doing so will help us overcome these hate-filled crimes and protect our communities and others from potential future harm. We will continue to proudly embrace our identities and stand together against Islamophobia, anti-Semitism, and racism. Thank you for your consideration. Signed, Rabbi Michael Z. Kahana of Congregation Beth Israel, Rabbi Ariel Stone, Rabbi Emerita, Congregation Shir Tikva, and the Board of Directors of Congregation Shir Tikva, as well as community members Craig Byrne, Sabina Lindler, Judith Morantz Herzberg, Judith Kloper, Daniela Ortiz Mendez, Stacy Burdett, David Newman, Sharon Stern, Joel Benin, Richard Goldenberg, Bija Gutoff, Eric Stern, Daniel Sharp, Barbara Reynolds Slater, Ann Goldberg, Rabbi Joseph Wolf, Rabbi Benjamin Barnett, Adela Bassain, David Levine, Phil Goldsmith, as well as 185 additional community members who are concerned about bias crimes and who have signed this community impact statement confidentially.
Okay. First, is there anything you would like to say before I impose the sentence?
No, my client would like to make a statement if he can.
Okay. And then after he makes a statement, I would like to hear any recommendation you have. So, Mr. Bivins, is there something you would like to say before I impose the sentence?
Stand up. Oh, yeah, okay. Stand up. Okay. Yes, thank you.
If you're more comfortable with being seated, it's fine for you to stay seated. And frankly,
Yes,
other
I would like
people
to
could probably
quote-
hear you better if you stay seated. But you're welcome to sit if you like. I don't take that as a sign of disrespect. And frankly, other people will be able to hear you better. And if you're more comfortable being seated, that's fine.
Okay. Yeah, so I would like to quote from the autobiography of President Richard Nixon, page 872. It was Robert Kennedy who authorized the first wiretaps on Martin Luther
So
King.
hold on. So hold on. So Mr. Bivins, so I'm going to ask that you direct your attention to me.
Oh, okay. Oh, okay, I will direct my
I
attention.
understand that obviously you're making the statement so people in the room can hear you, but
Yes.
I think it'll be best if you just look at me or you look down at
Okay.
what you're reading.
Oh, just to quote again, if you missed that, from the autobiography of President Richard Nixon, page 872. It was Robert Kennedy who authorized the first wiretaps on Martin Luther King.
That's your statement. That's the entirety of it. Okay. Hold on a second.
Sure.
All right, Ms. Hersher, what is your sentencing recommendation?
My recommendation, Your Honor, thank you, is that you follow the recommendation made by the state. Mr. Zemmel and I have discussed it at length. And I know that the kind folks in the room today were instrumental in coming up with that recommendation, in that the idea was to not put my client in jail and throw away the key. And I appreciate that compassion very much for Mr. Bivins. I think the period of supervision afterwards is also appropriate, and I will be his attorney. I will stay on as his attorney as things come up. I assume it will be probation to this court. And we'll proceed from there, but I would just ask that you follow the recommendation. That's it. Thank you.
All right, I appreciate that, and I will say that even if the defense had asked for some lesser sentence, I would go along with the state's recommendation, because I think the state's recommendation in all the circumstances is reasonable. I do want to make some comments. I think that it is important that there is a significant sanction, and a 5-year prison sanction with 5 years of probation is a very significant sanction. It'll technically, as a practical matter, be 4 years of supervision, because 1 year of the supervision he'll be in prison. That's the year from now until he's out. But it's important that there's a significant sanction, because these aren't just crimes against the person, they're crimes against the community. And not only are the crimes against the community, it appears they're intended to be that way. And I want to especially thank Rabbi Kahana. That was a very eloquent historical perspective you gave me, things that I wasn't aware of. Certainly not in the level of detail that you gave, but I think your statement shows how damaging these kind of actions are to the community, and also could explain motivation why someone would do that. I also want to thank Ms. Schneider with the idea that religion balances judgment and mercy. And in a perfect world, it sounds like you would have been hopeful and happy to have a restorative justice situation. But to have restorative justice work, you have to have both sides willing to do that. And it sounds like that wasn't something that was going to happen, so I appreciate that. And then for Mr. Green, I appreciate that despite what happened, that you were willing to forgive Mr. Bivins, and I think that, that says a lot. So, but as I was mentioning, these really are, they're crimes against the community, and attacking places where religious communities gather is more than just a crime against property. And it's particularly heinous because for people who practice religion, whatever their religion may be, this is the place they're gathering to practice religion, and it's supposed to be a safe place where they can focus on their faith, and they can be comfortable with other members of the community. And if that safety is destroyed, that doesn't just impact that personally, it impacts the way they practice their religion. So it's not just damaging a building, it's attacking the safety of an entire community. And we didn't have anybody here from the black-owned business that was damaged here, but it's similarly targeting a business just because it's owned by a black person or black people also damages the sense of safety in the black community, because the attack is meant to not just hurt a building or break a window, it's to send a message to the entire black community. So it's particularly problematic. I will say this case is it's a really sad situation because there's real emotional harm to the members of the Jewish, Muslim, and black communities, and a real loss of safety to them. And it's also sad from Mr. Bivins' perspective, because from what I understand of Mr. Bivins, it sounds like he was at one point on a solid track. Then he was a journalist for a time. Things seemed to be going well, and then something happened that caused his life to spin out of control, and lost his marriage, lost his job, lost his housing, and potentially losing a grip on reality, and apparently went down a white supremacist rabbit hole. And it appears to me that mental health issues strongly contributed to what happened here. And I want to be clear, not everyone who expresses such viewpoints has mental health issues any more than the normal person has mental health issues. And not everyone who has mental health issues expresses such viewpoints. But I will say, based on my limited interaction with Mr. Bivins in this case, which is really related just to the trial and pretrial hearing, but then also what I observed today, it appears to me that there are some significant mental health issues that need to be addressed. And I'm hopeful, I'm really hopeful that those issues can be addressed during probation. Not hopeful that that's going to be addressed much in prison, but it'd be great if they could be. But I'm really, really hopeful that it's not just regular supervision, but it's very close supervision that is addressing the mental health issues, to address the underlying issues so things like this don't happen again. And frankly, I hope this is a mental health issue, because at least mental health issues can be addressed. If it's not a mental health issue, and if it's much more concerning to me, because when someone has these kind of beliefs, people can have their beliefs, but when they act on those beliefs in a criminal way, that's much, much more dangerous to the community, because you can't do much to change people's beliefs. And the more baked in the beliefs are, the harder it is for them to change. And so that is a significant concern. But I would hope that even if it's not a mental health issue, that Mr. Bivins will realize that the amount of time he's spent in custody and will be spending in custody is enough to say, I'm just never going to do something like this again, because I don't want to go back to prison for that long. So I will also say, it's, as I mentioned, I was going to go along with the state's recommendation regardless of what the defense said. I think it's a good sign that Mr. Bivins is going along with that, and his attorney's going along with that. And it is significant to me that the victims in this case in the DA's office are not asking for the maximum prison sentence, but are asking for a lesser custody sentence, but a greater probation sentence, for the very reasons I expressed, that it's important that he actually have supervision and try to address these underlying issues, because just sending someone to prison or jail doesn't address underlying issues. We need ways to address those issues. And I'm really hopeful that Mr. Bivins can get help, and that he actually will make an effort to get the help. And I think it's important that all the victims here are showing a sign of forgiveness and a hope for redemption, while also recognizing that it's important to have consequences for bad actions. And so I'm truly, truly hopeful, for everyone's sake, Mr. Bivins and everyone else in this courtroom, that Mr. Bivins gets the help he needs and never does anything like this again. And then, to the extent that there's anybody else out there that might be contemplating doing the kind of things that Mr. Bivins has done, that they will realize that even though he didn't get the maximum sentence, that he's getting a very significant sentence. And 5 years in prison and 5 years in jail is a very long time. And hopefully that would be enough for someone to say, you know what, I have these views, but I'm not going to express them this way. I'm not going to go attack a particular community. So I'm hopeful that the sentence today actually would provide some disincentive for people to doing something similar like this in the future. So with that, I'm accepting the state's recommendation set forth in their sentencing memo. So count 1, arson in the first degree, is let me back up for a second. Is it appropriate for me to sentence in order of the counts, or should I sentence in a different order?
I think given the agreement of defense, I don't think we'll have an issue if the court goes in count order, but the technical correct way to do so, I believe, would go in the timeline order that the state had written out previously. But I think if defense isn't objecting to how we're getting to the math, the court can just go in count order.
So you're talking about the timeline on page 6 and 7?
Yes, because otherwise if you get to count 1, you're starting at a 7C before you've announced the prior sentences.
All right, so Ms. Hersher, and I guess the question is, for the judgment itself, it will go counts 1 through 11, I'm sorry. Does it matter to you what order I pronounce them in now? I guess just to be on the safe side, I can pronounce the sentence in the order that the DA is asked on page 6.
Right.
And then the judgment itself will refer to that, or do you want the judgment to even go in order of?
What I'm wondering is,
listed here?
should there be one that's the lead charge that the others follow? Or is it, what are your thoughts about that?
I would recommend the court just, the lead charge is count 1 as anyway. I would recommend the court just go in order counts 1 to 11, with the understanding being that the technical announcement of the sentencing, even if you're not performatively doing it here is as laid out in the state sentencing memorandum.
Ms. Hersher, do you agree with that?
I think that will work, yes.
Okay, so
One
just-
thing, if I may though, on count one on page 8 of the memo, it does say 20 months DOC per ballot measure 1157, excuse me. But I think that's a probation, downward to probation, is that correct?
Yes, Your Honor. So on count one, there's two sentencing criteria. One is the 7C grid block, which the state is asking the court to
Disregard that.
upward durational, downward dispositional 5 years probation. There is 20 months mandatory per BM 57. The state's asking the court to make the findings to depart out of the BM 57 sentence, which is for multiple reasons, but mainly that it will ensure that the amount of time over Mr. Bivins' head is not being eaten up in prison by imposing that 20 months DOC sentence. It ensures the time it remains for the probation.
Right,
And
so,
that's what the column on the right for count one says, right?
Yes, the last line on the right column. So I was just noting what the presumptive was, but I'm asking the court to depart out of that sentence there.
so for the purposes of the judgment, what I think the court might be getting at is, so probation for the first ones is the 5 years, and then starting with count 2, 20 months DOC consecutive to all counts. So do you need to say 20 months DOC and then all the rest are going to be consecutive to count 2 for the purposes of the judgment? Clarity?
It seems like if we do count 1, 2, and 3, or no, so counts 1 and 2 are each 20 months, that's 40 months.
No, 20 and 18.
Count 3 is 18.
Right.
So that would be a total of 58 months. And then we would go,
There's no 20 on count 1.
So there is a 20 on count 1, but counts 1 and counts 2 are the same incident. So they
merge.
They don't merge, but the BM 57 exposure doesn't stack because it's the same incident. So they're not merging, but it should go 18, 20, 22. The reason why 20 pops up twice is because that incident at the Muslim Community Center is the only one that has 2 felony property charges for the same incident because of the arson. So it's not a merger issue.
Okay. So one thing we're all going to be clear about is it's a total of 60 months of prison.
Soft
Yes.
time, all
And
credits.
so there'll be a certain amount of time that's consecutive and the rest would be concurrent.
It's actually all consecutive time because it's 18 plus 20 plus 22. That it's exactly 60. Unless I did my math wrong there.
So this isn't, straight
It's all
probation.
what's on the recommended
Right.
side.
But do you have to say what it's consecutive to is what I'm
It's-
saying? They're consecutive to each
So
other.
count 2 is consecutive to count 3, and count 3 is consecutive to count 4. And that's how we get to the 60 months on those 3 counts.
Okay.
And so count 1 is concurrent.
Well, it's a probationary sentence, so
Oh, okay. Oh, okay. I'm sorry. I was looking at the wrong column. All right. So are we all clear on that?
I think, yeah.
Okay. So bottom line is there'll be 60 months in prison with all credits and 5 years of formal probation with part of that would be served while he's in prison. And so as a technical matter, so count 1, arson in the first degree, is a grid block of 7C. This is a presumptive 20 months in prison, but there's going to be a downward dispositional departure to probation and an upward durational departure to 5 years of formal probation. As part of the probation, there'll be no contact with any of the named victims, and I guess the question is, are the named victims just the people listed, or just the entities listed in the indictment?
yes, Your Honor.
Okay. And no entry provisions for any of the addresses for the entities listed in the indictment. Part of the probation will need to do mental health and substance abuse treatment. And I should say evaluation in any recommended treatment. GPS monitoring will be authorized for the PO to make that decision. I'm going to, as part of the probation, I'm going to order that Mr. Bivins take and complete the appropriate educational and sensitivity training. I'm not going to specify what that is, but that's for the probation officer to have him complete such courses.
Does that exist at this time? And I'm trying to understand the scope of that, how that would work.
I can provide some examples of things that could apply, Your Honor. I know there is a course from the University of Colorado in Boulder that has a free online course on anti-racism. It's a multiple class course online. Another suggestion is to read books from the Harvard Kennedy School Racial Justice, Racial Equity, Anti-Semitism reading list and write about those. Just a couple of ideas of things that he could do.
So I'm actually, didn't think about that. While I don't share Mr. Bivins' views, I'm not sure if what we can do is try to reprogram him.
I don't think
part of probation.
I don't think it's not reprogramming that he has to take a test afterwards and say, here's all the things I now agree to. But I think it's appropriate to read things or to take courses where you're exposed to things such as even sitting through this trial and hearing the people talk today about the impact on this. Hopefully, at some point that may make an impact on you to realize how it impacted them. So even if it doesn't change his minds, I think it's appropriate to have him to do those things to at least expose them to those different ideas.
Okay.
All right, so that's count one. Count two, criminal mischief in the first degree. That's a grid block of 2C. This will be 20 months prison. And that'll be consecutive to all counts. Count three, criminal mischief in the first degree is also a grid block of 2C. That'll be 18 months prison, and both count, all the felony counts will indicate on the judgment pursuant to ballot measure 57. So count three is 18 months prison. That's consecutive to all counts. There'll be 2 years of post-prison supervision. So you'll have both post-prison supervision and probation. I understand there's a stipulation of restitution in the amount of $2,322.25 to the congregation of Beth Israel. Is that correct, Ms. Hersher?
Oh.
Or is that, do we have to leave that open?
Yeah, we'd like to revisit restitution later. Those were, the restitution amounts were part of the trial and were part of the evidence that came in at trial. But as to the requirement for restitution, there's a constitutional argument that I did not brief. I didn't realize this was coming up today.
All right, well, it sounds like we're going to
Let's address that later.
We'll have to leave restitution open for 90 days.
Yes.
And if you can reach an agreement, you can submit that ex parte. Do you want to have Mr. Bivins' appearance waived, or do you want to have him transported from prison for any restitution hearing, or have him
He
appear
would like to be transported, but
what about appearing remotely?
No. Transport.
It's very uncomfortable to do that. We'll talk about it.
Please.
Okay, he wants to be transported.
If he wants to be transported, you can do that, but it means you're going to be sitting on a bus, handcuffed, in a very uncomfortable position.
So,
We would.
yeah, the argument, just so you know, and I won't go into it, but the idea is that there's now among the defense bar an argument that restitution, in addition to, it was evidence in the trial, but that it should be a jury question on the verdict form. And so I can brief that, and we'll discuss that later if we leave restitution open.
That came up in the trial. It already rejected that, right? Was it?
I don't think so. Not with us. Mr. Zemmel and I discussed it, but do you remember if it came up?
I mean, I have a memory of it coming up, Your Honor.
Okay.
I will say I have a memory of this coming up, and I ruled on it. I just can't say it was this case, but it was another trial around this time.
Okay.
But I will say, I can tell you my ruling in that case was that it is not a jury issue.
Right.
And that it is something that is done afterwards. So even if you were to brief that, I would reject that.
That said, thank you for reminding me about that. That said, then, these are the restitution amounts that were developed in trial as evidence. Is there any differences? They look the same.
These were the restitution amounts that were provided to us via the restitution forms prior to trial, but I believe are reflective of what we also heard in trial. So if the only objection from defense is
then we don't object.
Is the argument about whether jury has to rule on it, I'd ask the court, you've made your
Yeah.
ruling on that and to impose the restitution and
Okay.
spare us the hearing.
And it was clearly set forth in the testimony, what the
Right.
amounts were, so we don't object.
All
Thank
right,
you.
so I will, so Mr. Zemo, if you can prepare an order.
I should have, I neglected to have that ready, but I will prepare it.
Right, but it'll be in the amount of $2,322.25 to Congregation Beth Israel.
That's correct.
Okay, so you can submit that ex parte. Count 4, criminal mischief in the first degree is a gridlock of 2B. This is 22 months prison per ballot measure 57. This is consecutive to all counts. And there'll be 2 years post-prison supervision. Count 5, criminal mischief in the first degree, grid block of 2I. This is not subject to ballot measure 57. There'll be 18 months formal probation. Restitution to Congregation Shir Tikva in the amount of $573. And it was at the same situation where the evidence, and I don't have my notes right
Nope,
now.
that's correct.
Okay, so I will issue a restitution order in the amount of that. I'm denying the defense request to have that be a jury question.
Right.
Count 6, criminal mischief in the first degree, square block of 2G, not subject to ballot measure 1557. That'll be 18 months of formal probation. And then for the remaining charges of bias crime in the second degree, which are counts 7, 8, 9, 10, and 11, those are all misdemeanors. And it'll be 5 years formal probation on each one of those counts. Anything else? I'm going to waive the imposition of fines and fees.
Thank you.
I want Mr. Bivins, if he has money, to pay the restitution off. Anything else for the record, counsel?
Just your, I believe it is the court's intent, but I just want to make sure orally on the record you are ordering that as to count 1 to also depart out of the BM 57 sentence, and that's written on the judgment.
Okay. I think I said it was a downward dispositional and upward durational departure.
Yes.
I don't know that I officially said it's a departure out of ballot measure 57.
Thank you.
So I am making that departure. All right, anything else for the record?
No, thank you.
All right, thank you, everybody. We're adjourned.
Thanks for coming. Appreciate you.
Okay. I will bring the paperwork down too. Okay.
Oh, my goodness.
Is that all right?
Bring it down?
Yep.
Thank you.
We're specifying, so you specify the restitution for both of them.
Gotcha. Good
Bye.
day.
I'll be down. I'll bring the paperwork down.